we were discussing in a different area, and then Dr. Chang called me up and informed me that you are looking at challenging the extension of time under the COVID Act. Yep.
Yes, correct.
I read the Pantahan letter to the ministry and also the text that you sent to Dato, and I'm a bit confused over the dates regarding the extension. Okay. Now, in your letter, you were saying that they managed to get a 12-month extension up to November 2022.
12 months?
Yeah. From this letter, the draft letter to the Surat Bantahan draft lah. It was stated that the developer managed to get a 12-month extension up to November 2022. Tetapi your text to Dr. Chang mentioned a different scenario.
I think the letter have a little bit of miscalculation there.
Okay.
The surat bantahan is for the new EOT. At that time, this 153 days is not in the picture yet. Let me just give a brief intro on the extension of time for this residency hektar.
The period.
Yes, the period. So bawah residency hektar ni, because it is a rumah wait project, so instead of 36 months, sepatutnya mengikut Housing Development Act 36 bulan untuk disiapkan untuk strata kan. Tapi untuk dalam kami punya sale and purchase agreement, semua orang punya sale and purchase agreement dah ditulis sebanyak 48 bulan. Bermaksud ada 12 bulan dah extension extra yang diberikan pada projek residensi hektar.
Daripada semalam lagi.
Yang buka lagu lah yang buat. Buka lagu.
Someone mute.
Kalau yang
Alright. Okay. So kesimpulannya semua projek rumah web dah diberikan 12 bulan extension extra daripada mula. Okay, yang ini kita dah bincang dengan tim Datuk Chang, and this we will tackle later lah. Lepas dah dapat kunci rumah, baru kita fight untuk yang tu lah. Tapi for now, sejak COVID melanda, sejak COVID ada, the EOT that we have been receiving ada dua setakat ni. Yang first under COVID Act is 167 hari. Yang extension yang kedua adalah sebanyak 153 hari. Mula-mula sebelum kami tahu ada 153 hari ni, developer maklumkan kepada kami yang diorang nak apply untuk setahun terus. So they already receive 167 hari, and then developer maklumkan kepada kami diorang nak apply extension untuk setahun terus sampai hujung tahun depan. But maybe because of our surat bantahan to KPKT or for whatever reason, the developer tak berjaya lah untuk dapatkan setahun, but instead they get the 153 hari only.
So
yes?
You ada dua surat sekarang? Ada dua surat?
Yes. Ada dua surat. 167 hari dan 153 hari. And according to the meeting dengan Datuk Jaya Selan, he mentioned that selepas ni KPKT tak akan meluluskan apa-apa EOT untuk hektar lah, but that is just verbally, so there's no confirmation on that yet lah. We try to get the surat lah from Datuk Jaya Selan side or KPKT side to confirm that there's no other EOT coming, tapi setakat ni tak ada lagi lah surat tu. So that's the extension of time for hektar lah.
Okay, let's make it clear. Let's get it clear. Something COVID Act from March 18 to August 31st.
Yes.
Satu tempoh. Itu automatic.
Yes.
It's automatic, right? From 1st September to 31st December 2020. Developer kena apply.
Okay.
Ada apply dah dia? Ada dapat tak ini tempoh? 1st September 2020 sampai 31st December 2020.
I think I'm not sure whether they apply ke tak, tapi tak dapat.
Ada, okay. So your second letter for 153 hari untuk tempoh mana? 1st January sampai 1st January 2021.
1st June.
Okay.
1st June 2020
biasa cakap.
sampai 31st October 2021.
1st June
2021 until 31st October 2021.
Oh. Maknanya 1st September 2020 sampai Mei 2021 tak ada.
Tak ada.
Oh, okay.
Nurah, bagi saya cakap sikit.
Yeah, sure.
Hello everyone, I'm Indra here. Okay, based on the fact from the what we call form application EOT from developer that what we call the engineer show to us, they apply for 1 year. The first one we not talk about 167 kita tak cakap, memang itu memang technically. Yang kedua dia apply setahun, which is the base, the exactly date I don't remember, but the hektar get only 153. Supposedly dia potong jalan sebab dia kena ikut urutan 122 hari. So dia apply setahun, then menteri decision give to them 153 hari. So the exactly date yang diorang apply is which is last year lah.
Yeah, fair enough. But kita only based on the letter sent by KPKT. So KPKT sekarang ada 2 surat.
Correct.
Under COVID Act.
Correct.
Satu untuk tempoh March 18 to 31st August. Betul tak?
Betul, correct. That's the fact.
Itu automatic. Itu automatic memang under the Act pemaju akan dapat. Tetapi 1st September sampai December 31st 2020 bukan automatic. Pemaju have to apply. Kalau pemaju tak apply, so tempoh itu tak akan diambil kira oleh for exemption, for extension.
Yes, I faham, Mr. Albert. Like engineer that said to me, and Dr. Jayaselan and his assistant said to me, they apply for 1 year sekaligus sepanjang masa tu. And then
dia apply, tapi kita akan guna surat yang dikeluarkan oleh KPKT. Yang
saya nak cakap, dia menteri hanya luluskan 153 hari, yang balance dia tak dapat dan dia tidak boleh buat rayuan lagi. Itu yang betul, itu saja yang dia boleh tunjuk. Dan form tu lah, cuma saya tak ingat date exactly yang dia apply. Dia tak tunjuk itu lah, dia tunjuk the latest one.
So now the surat kedua yang menteri approve ialah untuk Jun 2021 sampai November atau Oktober.
It's not my second October.
The second letter.
October.
October.
Lola, can you check?
October, Indra.
Correct.
October, correct. October.
Yeah.
What you do is, Nora, WhatsApp over to us the letter 1st of June 2021 to 31st October 2021.
Yeah.
WhatsApp over to us the letter. That's the letter that we know we're supposed to challenge.
We did WhatsApp you, Datuk Chang.
Yeah, because I saw the letter.
I'll forward again.
Okay.
I saw the letter.
What's the date of letter, Albert?
20th May, if I'm not mistaken.
20th May, yeah? This year lah.
Wait.
Last year.
Last year. Wait.
Last
Let me
May,
get it. Let me
last year,
get
this year? I think it could be this year.
Yeah,
Otherwise,
this
how we
is
challenge it?
correct from
20th May this year.
This year, yeah, 20th May this year, they backdated 1st June 21 to 31st October 2021.
No, you see, Dato, the KPKT letter is 11 May 2022. KPKT letter is 11 May 2022.
11 May, okay. All
Yeah,
right,
but
okay.
developer only serve it on the buyer while while a letter dated 20th May.
20th May, okay.
Right.
So the communication only happened on 20th May.
This year.
This year, yeah. So our 3 months will be from 20th May 2022 for judicial review.
Okay. Maybe explain the 90 days judicial review to them, Albert.
Yeah. Jadi jika kita nak challenge EOT ini for the period June sampai Oktober, kita ada masa 3 bulan dari tarikh the date of communication of the decision of the minister. So surat KPKT was sent to your while a letter dated 20th May 2022 by the developer. So kita ada 3 bulan untuk memfilekan judicial review from the date of the developer letter. This is pursuant to the rules of court, Order 53.
So 3 bulan from 20th May, not
Yeah.
11 May.
Not 11, but the rules say that from the date of communication.
Yep. But sometimes to be on the safe side, adopt the KPKT's letter 11th of May, so that you give yourself enough time,
Enough time now, right?
11th of May, let's adopt 11 May as 90 days from there. So therefore, it should be 10th of August, should be your last day to file. The developers were communicated to you on the 20th of May. Sometimes I like to be prudent, use the KPKT's letter. So give yourself deadline 10th of August 2022.
Okay. So sorry, but can I ask a question?
Yeah, please go ahead.
So what happened to the in between the period that they got for the EOT from September 2020 until May 2021?
My view, if there is no letter from KPKT, that period is not taken into account. It's not exempted. It's not considered as extended.
Okay, all right.
Yeah.
But then so meaning that the new date that we got, so meaning that it should be earlier than that, right?
Yes. So what we normally do is when we sue for LAD, we will do the calculation from the date of deposit, all right, 36 months. We get the date that they are supposed to give you the vacant possession, and then we will take the date that they actually give you the vacant possession. We will calculate the number of days delay, assuming, let's say, for example, it's 500. Then we will minus the two letter, 167 and 153.
All right. So okay. So meaning that when we contesting for the LAD letter after we got the key and so on, so meaning that we can include the gap.
Yeah, the gap.
Yeah. So that will add to our compensation letter.
Yes,
okay,
because
right.
they didn't get any letter.
Yeah,
they don't have any approval.
Okay. All right.
Because that period is not automatic. That period they have to apply.
Okay. All right. That's clear. That's
okay.
Clear.
Unlike in East Malaysia Sabah Sarawak, the Minister of Housing dia memang kasih extension sampai end of December of 2021.
Okay. All right. Okay. That's clear on the date, right? The date is clear now. So yeah, I think we would like to hear more about the judicial review, because I think most of us are not from a legal background. So I think they should be noted on what you are contesting actually. So maybe you can give some background to it, Albert.
Okay, judicial review basically is to challenge the decision, mencabar keputusan the minister, all right, public authority lah. When a public authority make a decision which cause an aggrieved party to suffer losses, aggrieved party here will be the pembeli. So under the Rules of Court Order 53, there is this procedure called judicial review, where the aggrieved party, purchaser, can file an application in court to challenge the decision of the minister. All right, challenge the decision of the minister on the basis that the minister decision is not valid because the minister did not give the aggrieved party a right to be heard. When a minister make a decision, this decision falls under the law of administrative law. So in administrative law, when the public authority, here is the minister, make a decision, the law of natural justice will apply. And the law of natural justice says that the person who make the decision must give the right to be heard to the party that is aggrieved by the decision. So this is the direction that we're going to pursue under our judicial review. All right, because even though Jai Silan told you that under COVID Act dia tak boleh buat apa-apa, dia mesti approve. All right, that is the ministry view lah. Ministry view. We don't deny the fact that under the COVID Act tak ada clauses lah, tak ada clauses that set out the procedure that the minister must listen to the aggrieved party. All right, we agree. We take note of that. Right. In fact, even the Housing Development Act also does not provide. Then does not have any clauses to say that when the minister make a decision, or those days when the controller make a decision, they have to listen to the aggrieved party. The pembeli. But as you know, in our Amingli case in the Court of Appeal, Justice Haminda has mentioned that by right, the controller should accord the right to be heard, be given to the chaser. This is pursuant to the law of natural justice. This is administrative law. So we're going to adopt the same line of argument as what Justice Haminda Singh says in Court of Appeal. All right, that when the minister consider the application by the developer under the COVID Act, walaupun COVID Act tak ada clauses yang mengatakan bahawa menteri mesti memberi peluang kepada pembeli untuk didengar, tetapi argument kita same as Housing Development Act, same as the decision in Court of Appeal, bahawa menteri sebenarnya mesti memberikan hak kepada pembeli to be heard. So because the decision made by the menteri in approving this 153 days to the pemaju without giving your right to be heard, so kita akan berhujah bahawa keputusan menteri tidak boleh diterima adalah salah. So basically that will be our line of argument in a gist . Saya tak nak cakap banyak-banyak sebab kemungkinan ada orang dari pemaju telah lock in hari ini .
I was going to say that, so just
Yeah,
Yeah,
so
let's
I
be
was
careful
on the
because
I
this
was a bit reluctant to
forum is
share lah.
open
that's
for
good.
owners. Therefore, there may be some
Yeah.
developers friendly party here, among our group.
Yeah.
Okay, let's be careful.
Dalam hari ni
Hello,
saya,
developer. Hello, developer.
I got a team of lawyers actually joined in our meeting today. Kita dah bermula lah buat research. Dah bermula buat research 2 weeks ago. Kita dah dapat case lah that is linked to this case lah, linked to this matter. Tapi saya tak nak share lah, sebab mungkin ada spy.
True. Better not.
So I was thinking kalau you are sure that you want to challenge, mungkin you boleh form satu small group or committee. Then mari jumpa saya, liaise with me directly, and then from there I can show you our research, our work, our argument, that kind of thing.
Just another thing about. I know we shouldn't tell this to them, but in case they are here. Anyway, just to scare them off, like because I heard that you were also involved in one the same contest about EOT COVID in one of the project under MRCB. So maybe can we get an update on that? Is it possible? I mean, is it going good, or because we just want to know the likelihood in our case as well.
I think it's not privileged to share lah.
Okay, all right. Okay, all right.
My apologies. No.
Okay, all right. Okay,
No,
that's fine. I just want to know the case. Never mind. That's okay. Right.
Each of us got our own strategy down here. We are working together as a team down here to make sure that the minister do not take us for granted and then unilaterally approve EOT for developers. It's a good challenge down here, and then we are so far HBA team of lawyers are on the forerunner for these cases, and then we have done a lot of researches as well.
Okay, all right.
Just to share, the buyers have until tomorrow to agree to the appointment of lawyer, and then we will set up another group, special group without any spy, and we can share more lah.
Feel free to contact me. Once you have decided, feel free to contact me. But I said I prefer to deal with a committee, and then you can communicate with the rest of them in your own chat group.
Okay, sure.
Okay.
That should be the way to do it lah. Sebab ada mole.
Yeah.
Correct. But we only challenge for those who are agreed to be taken as a case, right? I mean, we go on the unit basis, right?
Yeah.
Meaning that we are not fight for everyone, right? That's
no. You see, I discussed it with Dato'. We were, although in your text, you dah beritahu Dato'.
Betul.
Ada 100 people. Boleh dengar tak? Boleh dengar? Hello, boleh dengar? Can you hear?
Yeah, now clear.
Okay, good. Now, Dato' has informed me that from your text, majority of the people, around 800 people, have indicated that they are willing to challenge the decision of the minister. All right. We prefer to go on the basis of a class action. All right, class action. Tetapi tak perlu 800 orang lah. Put their name into the court paper. We were thinking that maybe you just choose around 100 people, 100 names. Some people may not want to put their name into it for some reason lah. Mungkin dia orang tak nak nama dia disebutkan di dalam court paper. So I leave it to the committee to sort it out. dapat 100 nama untuk saya. A class action, right? So akan beri satu
kalau 100,
kan begitu?
kalau 100 orang pembeli, maybe we can include yang beli tahun paling awal lah, around 2018, pembeli paling awal.
Tidak, because this is for JR.
doesn't matter.
This is for JR. No, this is for judicial review. The date of SMP tak penting lah, tak penting. Right? So you just choose maybe 100 should be good enough lah, Dato'. I think 100 should be good enough, right? Bagi satu impression kepada hakim bahawa ini ada effect a big
Massive,
group, a big group of purchaser, you know, a big group of purchaser.
But psychologically, I think 101 would be a message to the courts that there are more coming in. When you have one extra, 101, 1,001, I would always have the impression that there are more out there not surfaced yet, you know. Perhaps have 101 would be better.
Agreed.
Yeah.
Okay. Can,
So kalau you dapat in the event kita menang lah, alright. So the decision will be for the benefit of everyone.
okay.
Semua orang.
So Albert, can you tell us what will be the implication kalau kita menang? So what will happen to us? What will the benefit that we get? And also what happened to the buyer? The developer.
Then that period of time that was approved by the ministry akan tidak dikira.
Okay. So maknanya bila AOT yang terbatal tu, tempoh yang terbatal tu, maknanya now the developer have no choice but they have to finish within the date yang barulah, yang akan baru selepas ditolak semua EOT.
Ya. Maknanya apabila kita sue LED, right? Kita akan menolak 167 hari saja.
Is it not 153?
The first one is 167 or 153.
Oh, the automatic 167.
Okay.
The automatic one. Dari March sampai Ogos 31.
Okay.
So kita akan tolak itu saja sebab itu automatic.
Okay.
Understand?
Alright.
Okay.
Okay. Terus
Ada somebody angkat tangan.
Yeah. Mr. Albert, can you hear me?
Yep. Go ahead.
Okay. Sorry. My name is Aisha. I just want to ask one question lah actually. Can we take the JR straight away before go to domestic revenue? I mean JR to go to tribunal first ke? Boleh pergi JR straight away ke? Macam mana?
No, the judicial review is only to the High Court, Civil High Court. Tribunal tak ada jurisdiction to hear a judicial review application.
Oh, sebab
tak ada masalah nak pergi straight to JR.
I ingat kena proceed pergi domestic revenue dulu. Tak ada Alright.
Another one, ada tangan? Ada dua tangan?
Hello, hi Mr. Albert.
Yep.
I just want to check with you. Okay, for this judicial review, can we include one of the prayer in that judicial review for the challenge on the first EOT? Because as per the SPA under the HDA, supposedly for strata title, it should be 36 months. But here in the SPA, it mentioned 48 months. So 1 year already on that. So plus 1537.
Yeah, for that 48 month, that one we will keep it for later part when we sue for the LAD. We don't put it under this judicial review.
I see.
We don't put it under this judicial review. All right.
Okay, sure.
The one is only when we go after them for LAD.
Okay, thank you.
For LAD, yeah.
You got to read the sale and purchase agreement. For the LAD, your cause of action only arise after vacant possession. Look into Clause 25(4). Bagi mengelakkan keraguan, apa-apa kuasa tindakan digunakan untuk menuntut ganti rugi, jumlah tersebut oleh pembeli di bawah fasa ini adalah terakur pada tarikh pembeli mengambil pemilik kosong petak tersebut. Meaning upon vacant possession only, can you then sue for the LAD? That is the 36-48 months LAD. Then later, here we are challenging the COVID issuance of the EOT.
Different case, huh?
Yeah.
Different suit. That one later on. That one after they deliver vacant possession, then only we will go after them for that 12-month period, right?
Okay.
Oh, still got people coming in. Any question? Any more question from the floor?
Yeah, please ask a question if you have a question.
Albert, you got a list of questions sent to us by Nora. I send it over to you. Maybe you can read questions.
Sorry. Hello.
Maybe Dr. you want to go through them and then on the issue of cost, then only I will answer.
Okay. All right. Nora, your first question is, if the judicial review decision or any other legal action did not side with the buyer, can the developer sue the buyer instead for defamation?
No, tak boleh. Because judicial review is your right, given under the rules of court under Order 53. Right? So developer cannot sue you for defamation, even your color. Right? So don't worry. All right? They cannot sue you. Developer cannot sue you.
Okay. And the party cost, maybe you could explain that area there.
Party cost, kalau you kalah atau kalau you menang, selalunya for judicial review sekarang the trend mahkamah the most we have seen the cost to be ordered to be paid is around 10,000. Right, to be 10,000. Kalau you orang ada 800 people, then your share lah, you know. But most of the time, because of public interest case, we have also seen that judges sometimes they order no order as to cost, the other order as to cost. Sebab ini adalah issue yang affect the public. So there are instances where the court took into that consideration and order no order as to cost, tak ada cost. Okay. Kadang ada cost pun for judicial review in a high court level, we have seen is around 10,000.
Yeah. For the winning party, that's only for the winning party. If you win, also developer got to pay you the cost. If you lose, also the losing party must pay the winner the cost. But like what Albert said, it's a public litigation, so it will depend on the judge. Sometimes we find a lot of judges very fair. For public litigation, there is no order as to cost. Both party no cost at all. Okay. Next question I've got here, the estimated cost to hire lawyer, process court fees. Some are afraid to join for the fear that the cost will be too much to bear. Will the cost be charged individually or per group basis, where we can divide and share the cost among us? What will be the payment schedule? Do we have to pay something first? This one, Albert, when it comes to costs, I think upon Nora, I will leave the meeting after you discuss directly with lawyer lah. So I don't want to campur tangan with the cost all that. All right. But your other question, Nora, that you asked is, our ROS application has been rejected. So we are in the process of submitting an appeal. Hence, setting up bank account will take a longer time and pose a problem. All that. See, we don't expect the RA to collect money from the people. I would suggest that the people who want to get involved sign directly and pay the lawyer directly, so the RA will not be responsible. Serve it that way better. Let the people who want to participate pay directly to the law firm and sign the warrant to act and the warrant to sign affidavits, all that directly with the law firm. That'll be better. So don't get the RA involved first. But why is your RA rejected? Is there a reason why the ROS rejected your resident association?
Indra can share perhaps.
Oh, Shafiq
or Indra can share.
Shafiq.
Sorry, I'm away. What's the question?
My question is, kenapa you punya resident association tidak benar di daftar di registry of society pertubuhan?
Okay. Basically, the registrar said that this this persatuan, sebab that alamat kita guna alamat people, alamat rumah orang. So dia cakap this residency hectare is not completed yet. So kalau mana-mana persatuan penduduk yang you nak buat, so dia cakap that rumah tu mesti kena siap dulu, dan baru you boleh form the persatuan penduduk.
Yeah, I think that that answer from pendaftar pertubuhan makes sense, because you don't have a residency address at all. So, but that is why at this stage I normally call ourselves a pro tem committee. Pro tem committee, Nora, you can be the chairman, another person be a secretary, just pro tem status only, buat sementara, until the house is completed. No need to have a formal resident association, because when you have a formal resident association, you got to start collecting subscription. Then you got to have the audited accounts. Then you also got to have the annual return submitted with the ROS. That's a lot of work to do, you know, because once your building is completed, you can have an RA. But next question is, why do you have an RA when I can form a JMB, joint management body, with a developer? So it's more like duplicity of work, you know, that's all. But for the time being, you can call yourself Pro Tem Committee of Residency Hakta or Action Committee of Residency Hakta. Jabatan Kuasa Residency Hakta terpulang pada you, and this word tak payah daftar punya the ROS. Okay, Nora, you understand?
Okay, we understand. We'll see to it.
All right. Now, next question here is, will this case or any court decision going to be unit by unit basis because need individual approval, or will the decision include those buyers who didn't join as well? We want to fight the case so that everybody can enjoy the benefit. But there'll be a lot of people standing on the sideline that all the dirty work done by you lah. They always ask somebody, you go ahead and do the work lah. Semua duduk saja atas pagar. They don't want to campur tangan. There will always be like that. So, but we must not give up. If everybody think that kind of mentality, nothing will be done one actually. Nothing will be done. So we need people like Nora to be the leader. You must lead the thing. In fact, you are doing a marvelous job, Nora. I must congratulate you. I see all the emails, the notices, the WhatsApp you send out, all that. I tell you, not only you got a good command of English, your command of Bahasa, your letter writing in English is also very good. Thank you.
But Dato', I'm not the president, Indra is.
I leave the internal over to you. But well done, Indra. Well done, Indra. Next one, Albert, is the question, what will be the expected timeline? How long will the whole process take? What is the flow of process? Albert, yours?
Okay, for judicial review, we have to first dapat leave from court first, right? It's a two-stage application. Kita nak, first of all, we got to get leave from court. Only when the judge feel that the issue that we want to argue is of importance, of public nature, and give us the leave, then only the actual proper hearing will start. When the actual proper hearing start, then the ministry, KPKT, will then come in and argue with me. So the leave stage is between me and the judge. I have to convince the judge that the issue that we are going before him are of public importance, you know. So it's a two-stage thing. One is leave, and then after, if leave is granted, then KPKT will then be informed, and then they will come in, all right, and to argue with me, all right, to also argue the case. So it's a two-stage thing. Sekarang, to go to court is very fast. The leave stage probably, I think, if we file in 2 months' time, we will get the hearing date. Provided there's no further lockdown,
Okay.
It's very fast. Now the court is very fast, you know. And bila kita dapat leave, then we got to serve it on KPKT, and then the legal department or the AG chambers will then file in the affidavit to bantah, to challenge, and exchange of affidavit probably take another 2 months. And then on the 3rd month of the actual proper hearing, we will get a date with the judge. So all in probably 5 to 6 months.
So first stage is about 2 months, first stage for leave, and subsequently the second stage will be probably the 5th month. Okay?
Yeah, 5th or 6th month.
Now don't forget, once the leave is obtained already, Albert will have to fight 2 fronts. One, Menteri Perumahan will be represented by Attorney General's office, government lawyer. The second defendant will be the developer themselves. The developer will bring the lawyers and try to go and argue the case with us also, you know. So it'll be 2-front fight when it comes to second limb of the this judicial review.
Okay.
So it's not a easy thing to do. Judicial review, first of all, we got a time frame of 3 months. All right, kita dah wasted almost a
1
month.
month.
Yeah, you know. So once you confirm, the committee, I must form a small committee. This small committee people must be dedicated. Tak boleh go overseas for the next 3 months. Cannot travel. Okay. When I call, must come and see me. All right, because time is of the essence. You know, time is of the essence. Right. When we do judicial review, normally very stressed because you know, of the time constraint.
Yeah. And antara semua pembeli dalam sebagai plaintiff, ya, pihak yang menuntut, elect one person to sign affidavit. One person authorized to sign affidavit. Edwina, you got anything to add, Edwina?
No.
Okay. All right. Now, next question. If all buyers don't agree to get one lawyer, can the other remaining buyers appoint another lawyer? Of course can. Anybody is liberty to get their own lawyer. In a case like this, sometimes you have 2 sets of lawyers coming in to fight the same case. But problem is, sometimes you got 2 sets of cases, you got 2 different judges, you know. That's the risk, you know. You got 2 different judges. So one judge will be for, one judge will be against, then you'll have a problem. In a same project but 2 different judges, you may have a problem there. That's why always try to stick with one lawyer if possible. All right. One more final question here, Albert. They're given me. We have high hopes and would be grateful if our case can be taken up on a pro bono basis, because most of us are all low and medium cost income earner and burdened by loan repayment while need to pay current rent. Now, HBA, we do pro bono cases, Nora. We actually do pro bono cases, but we want our pro bono cases to reach as high as federal court first one, you know. We don't argue from a bottom all the way there, and we have got very important case that is going to be argued in July next month. Very important case, you know. This case was done by the High Court lawyer. They won. At the Court of Appeal, they lost. And now at the High Court, at the Federal Court, we volunteer. Our group of lawyers come and volunteer to fight the case because it was a matter of point of law there that is very important. We had to establish a point of law in a case next month, and that was done pro bono. So we want to see case-to-case basis. We cannot be running to everybody in this world. In fact, I've got a lot of cases inviting me to be on the chat group. Kalau saya masuk semua orang punya chat group, saya tak payah tidur lah. Semua nak minta saya masuk dia punya chat group. Allah. So I said, if you got problem, Nora, you communicate with me only. You get the questions already. Tak payah masuk chat group lah, because I'd rather deal with one person rather than dealing with 25 questions on the line. Itu saja, Nora. Saya nak jelaskan.
Okay, understood.
But I can assure you, Nora and the group that later on when I discuss with you on my fees, All right, I will talk to Dato Chang, and I know I'm from Sentu. Saya dari Sentu. So I know what you're talking about, because I came from that area, So don't worry. All right. The fees that I'm going to quote you sudah discount 50%.
Oh, discount. Okay, that's good.
I think Alvin mentioned why he's from Sentul is he come from right to riches lah. Dulu orang miskin, bapa miskin, sekarang okay. That's all. I think that's what I tell you.
I can understand. I think President Hatta is at the other side, the Gombak that side, right?
Yeah, so we got another person from Sentul as well. So maybe for 50% more discount.
Orang kampung.
Oh, then I will put extra 50% of extra hours inside. I'll get all my players to come back to work on Saturday, Sunday.
In fact, in this discussion also, Albert, your whole team is there, right? Your team?
Yeah, my team is there. Yeah.
Your whole team of 5 lawyers are all watching us, discussing. That's why they're taking notes. And then they are all excited to find this case to do research for the boss lah. Itu saja. Okay, we would like to invite some more questions. Any more questions?
I have one question regarding the right to be heard just now that you mentioned, because that day we had a friendly discussion with the KPKT punya officials, the staff that, because we were saying to them that how come before this tak pernah pun tanya pasal buyer punya bebanan and so on, right? So and then the simple answer that they give to us is that it's not practical to ask everyone. If I can say, if I quote lah, because you have, like in our case only, we already have 2,000 plus, right? If KPKT want to make a fast decision and they have to ask everyone, maknanya project lain juga. So they mentioned to us it's not practical. So that's why they just follow the COVID act and so on. So
okay, my response to them is that mereka tak ada mekanisme. Kalau tak ada mekanisme, bukan tak boleh buat. It's not something that is impossible to be done. If the developer can sell 1,000 house, you think he cannot gather the 1,000 house in Dewan Orang Ramai, invite the minister to come and explain to you all, dan minta sama ada bantahan atau kita semua setuju dengan jelasan menteri tak? It's something impossible, Don't forget, it's 1,000 is very little. They don't have mechanism, never been done before, doesn't mean that it cannot be done. Let me read out what the judge in court appeal decision, Justice Dato Haminda said, let me quote you. We will accordingly surmise that the minister who was entrusted with the discretionary power under the housing regulation must act fairly. In our view, it does not matter whether the discretionary power to be exercised was judicial in nature or quasi-judicial or even a purely administrative one, as the rights of the purchaser to claim damages in the event of delay would be adversely affected or even extinguished by the exercise of such discretionary power. It is our judgment, the Court of Appeal judgment, that purchaser must be given an opportunity to be heard prior to any decision made. Since no such right was accorded, the decision of the minister cannot stand and must be set aside. Now, this was a case that we fought in Ang Ming Lee's case against the Minister of Housing all the way to the federal court. Kita dah menang. We have taken a lot of cases of federal court, and that is why HBA, we are quite strong in our group. When it comes to swing minister, we find very positive lah.
Okay.
In fact, my article is completed already. It's just a matter of publishing. My article, sometimes I get kicked out of it.
Mr. Chang, Mr. Chang, you do realize it's not the minister's personal money that's going to be forked out.
Yeah, correct.
Yeah, right.
That's why I always start my article by saying, at the stroke of a pen, money is payable to aggrieved house buyers are taken away by the minister. The fact that he signed the extension EOT indirectly means, saya punya pampasan extinguished already lah. Mana dah jatuh? That's what happened. So the minister must be careful when he gives EOT. That's the purpose of this challenge here. Did he do it fairly, rationally, and must at least ask the aggrieved buyer? You are the affected mangsa. You are the victim. How come he didn't ask the victim? Period.
Okay. And another thing, if I can ask Albert, kebanyakan, I'm not kebanyakan lah, I think some of us are very skeptical to go, to take a legal action to this developer, because they're afraid that if, let's say we win the case, right? And then that will implicate their financial, and then at the end, they got a low quality house, and probably the house get abandoned and so on. So how can you explain to these people who have this kind of thinking? That sense.
You see, what you're fighting is only for a period of 153 days, right?
Yes.
But there may be some developer mole here. Be careful with our words.
So 153 days taken out from the calculation of LED, I don't think so you will affect much of the developer's financial situation.
Oh yeah. Bayar insurans 3 bulan pun tak ada bayar.
But don't forget I think your committee did a little bit of research, developed other project, Green Park Village. Don't forget, Green Park Village, they're there under the same name. Sometimes we get a lot of situation whereby developer threaten the house buyer lah. I'm not saying this developer. Some developers say, kalau you nak sue saya akan move please come saya punya company, meaning you declare bankrupt, all that. But it's very common in the industry. A lot of developers say a lot of things, in such a way that they will discourage you from doing certain things, all that. All right.
Okay. I think quality of house will not make. I mean, whether you get a good quality house or bad quality of house, it won't be because you sue the developer for this 153 days things lah. I think at the end of the day, the quality of the house will depend on a lot on the main con, whether the main con is been paid in time, and the architect, whether the supervising of the construction. All these play a part. There are so many other factors. I don't think at the end of the day whether you get a quality house or no quality house is linked to this judicial review suit. I don't think so. There's so many other factors. Relating to whether you get a good quality house or bad quality house. Definitely not this suit.
Can I just give a very lay response to that about if kalau you takut dia nak buat hal nak bagi you at the end of the day rumah yang banyak cacat celah, it will backfire on the developer balik, because then only you boleh pergi tribunal minta ganti rugi untuk the defects yang ada dekat rumah, and benda tu dia tak boleh nak lari sebab dah ada dalam you punya SPA. Kan, kalau you dapat, masa you dapat rumah tu, you kan boleh semak ada cacat celah ke, dan developer pun ada tempoh period yang dia kena perbaiki balik. Jadi kalau dia nak ugut dan kalau dia betul buat tak betul rumah tu, kena balik dekat developer. Pembeli masih ada hak untuk claim ganti rugi, untuk paksa developer baiki segala defect yang ada ataupun yang dia sengaja diadakan. I think it will be very stupid for the developer to actually act on such threats lah. I don't know.
Dia kuat bitter this developer. Dia bitter good.
Okay, I've just sent my video over to Nora. Why new doesn't mean perfect? A lot of people think that I buy new house, semua perfect. Mana ada perfect in Malaysia? I tell you, we don't have perfect contractor. We only got those Indonesian worker who was a farmer last year in Indonesia, came to Malaysia, sekarang become supervisor.
Wow.
That's the standard that we got. I'm telling you. look into my video I just sent to Nora.
Yeah, I just forward to everyone.
Thank you. All right.
Uh, So next question.
Yeah, we give to others.
Maybe others have the questions.
Yeah, just ask directly. Yeah, this is the chances.
Okay, if there's no other question, Albert, maybe I and Adriana can be excused on the meeting. You discuss with Nora and the team lah on the legal fees thing lah.
Nora, you prefer to discuss it now, or you prefer to contact me tomorrow, or what to discuss? Because like I said, we do not know who is in this meeting today.
Maybe we'll send another link.
Yeah, maybe you confirm because you said tomorrow is a deadline for them to come back to you. All right. So once you get the confirmation, contact me tomorrow. You got my number?
Yeah.
You got my number?
Oh no.
No.
Can we just continue after this? Maybe with a new link?
Nora.
With a new link.
Nora. Hello?
Yeah.
Hello?
Please.
Nora, can you privately discussing with Mr. Albert after the end of the meeting?
Yep. Good.
Okay,
new link lah. That's what I
new link.
New link.
Better that way lah. Better that way. I think we keep it P&C first, you know.
Yep.
Okay.
Okay.
All right.
All right. Okay.
So the new link will only include Wakil Block lah, not everyone.
Yeah.
Because we haven't vetted through everyone yet.
Yeah, just a committee. Because we still have to discuss what are the things you need to get for me. We need to meet up, you know. There's a lot of paperwork to do, you know, when it comes to filing a judicial review. All right, the number of photos setting, you know, I mean that everyone must SMT got to give me a copy. Because all this are got to be put it in as an exhibit, you know.
Alright,
So can you imagine the amount of photo setting that I have to do? A lot of things need to be done, you know. So it's very cramped. We really lost 1 month. All right. So maybe you can send a link to me afterward. Then we can have a quick discussion. All right. With the committee.
Okay, sure.
Mm-hmm.
All right. So anyone else have any other questions?
Please ask. This is the
Maybe in the chat room.
Is there any question in the chat room? I don't know to use this.
What happens?
So you ada cakap.
Okay, I'll just read the questions. What happens if the minister who allowed the application from the developer fail or ignore to attend to the court? What are the chances for the buyer in order to be entitled to LAD?
Well, how do I read the thing?
You just click a button like the
conversation
round button down there.
Oh, under chat,
round
under
button.
chat, yeah, under chat, yeah.
most left.
Okay, I have a question. What happened if the minister who allowed the application from the developer fail or not to attend the court? Or if they fail to attend the court, then if we fail to challenge the judicial review, then of course we will submit our point, right, to the judge only, and then the judge would then only consider my argument.
Okay.
You know, it's not automatic. We will still get it, you know, because I still have to convince the judge about our argument.
Okay.
But the minister will not attend court, definitely. They will get the government lawyer to attend. That's Attorney General's chamber. AGC will attend bagi pihak the minister one. Don't worry, they will turn up one.
Okay.
Please, anyone else have a question? Please ask. This is your opportunity.
There's one question with a hand up.
Okay, from Aslam, he said, what are the lawyer's strategy to solve the issues? So maybe this we will discuss later when we have a special group. Second question is, will the strategy works? How confident are the lawyers with these strategies? Okay, maybe we'll discuss it later as well, privately.
Yeah.
The third is, do you have any opinion on the genuinity of the second extension letter? It's very genuine. We have confirmed with KPKT on the 150 days, 153 days. Yeah. The extension bukan main-main ya. Yeah, it's 153 days. Okay, ada soalan lain ke?
Soalan lain tanya, it's okay. Tanya.
Boleh tanya direct.
Tanya direct. Ada lagi? Angkat tanya tak ada. Tak pun boleh tulis dekat chat box, we can read for you.
Hi.
Oh, okay.
Hi, Shafina here. I just would like to ask regarding yang HBA 36 months and but the SPA 48 months. Anyone know about that one? Can explain to us. Hi.
Come again.
My name is Shafina. Okay, I heard about somebody mentioned on actually according to HBA strata title 36 months, but in our SPA is 48 months. Can anyone explain on that, because we are not familiar on this matter?
You see, when you buy a property from developer, the sale and purchase agreement is governed by the Housing Development Act. The developer got to follow a statutory format of SPA. All right, the statutory format of SPA under the Housing Development Act provides 36 months for the developer to deliver vacant possession. All right, it's stated in the statutory SPA. What happened is before Ang Ming Lee, the case of Ang Ming Lee, developer will apply to the Ministry of Housing under Regulation 11.3 to amend the clause 25 to deliver the vacant possession from 36 months to 48 months. So before the case of Ang Ming Lee, KPKT will then usually will approve the developer application, all right, to 48 months. So when the developer get the approval letter from KPKT, the developer would then amend the sale and purchase agreement, all right, from 36 months to 48 months. So what you sign, when you sign the agreement, all right, the agreement, the SPA agreement is already been amended from 36 months to 48 months. Now that was done at a time before the case of Ang Ming Lee, which HBA lawyers has taken up the case pro bono, and we fought all the way from the High Court to the Federal Court. And in Federal Court, the Chief Justice Tengku Maimun has ruled that the power of the controller to amend the statutory SPA, all right, under Regulation 11.3 is ultra virus. In other words, the approval given by the KPKT to the developer to amend 36 months to 48 months is not valid, because the power that was given to the controller under Regulation 11.3, Regulation 11.3 has been ruled to be ultra virus. So in other words, the developer must deliver vacant possession to you within 36 months, not 48 months. This is in a gist. In a gist, I try to explain it in a layman explanation. All right. So in other words, even though what you sign is 48 months, all right, but under the case law of Ang Ming Lee, the Federal Court has decided that the time to deliver vacant possession should be 36 months, not 48 months. So we will keep this to the later on when you have got your keys, got your vacant possession, all right, then we will sue the developer for LAD, for late delivery damages. And our argument would be that the developer must deliver the unit, the condo to you within 36 months. So if they have delivered above the 36 months, all right, kita akan calculate lah how many days delay, and then we minus the 167 days, and the balance days delay, we will then compute how much LED they have to pay to each and every one of you. The one later part lah.
Yeah, I like this one. Shah Hozamboy 87. Terima kasih semua. Barulah ada semangat macam ni. Wah, serius. It's a very good comment from Inche Shah. The next comment from Razif. There's been some of the buyers had threatened by developer due to some bad review in Google. Does this make sense? That's all. This one here, just be careful because we have been pre-warned already. There may be some developer mole in here. We be careful with what we say, all that lah. Okay, they will always be there to discourage and whisper back to the developer one. Okay. Next question I see here. I noticed the letterhead format. Statutory name of the first extension letter is different from the second. Is this normal? That's all. I noticed the letterhead format signatory name of the first extension letter is different from the second letter. Is it normal? Is he talking about Dr. J.S. Seelan? The talk about J.S. Seelan is his name was J.S. Seelan. Sekarang, effective this year in February lah, he became a doctor from Pahang. That's all. He got a doctor from Pahang this year only. Okay, any other question? The other good question here, Albert, maybe you'd like to explain LED calculator from SMP date or booking date?
Booking date.
Yep.
From booking date, and this is also thanks to HBA lawyers. All right, HBA lawyers have taken up this argument. All these years, every lawyer calculate LED from the date of SMP, right? But in the case of PJD, one of HBA lawyers went to court and fought all the way to federal court. Again, a decision by Tengku Maimun, the Chief Justice, who ruled that when there is a delay by the developer in giving vacant possession, the date to start calculating for LED should be the date the purchaser pay the deposit, not the date of the SMP.
Yeah.
So from PJD cases now, you dapat lah a few more months extra lah kalau you ada bayar deposit earlier. Thanks to HBA lawyers, Dr. Andy Wong.
Thank you so much.
After VP lah, we come to that. Because in your case, I think Nora, you sent me a note. Booking fee $500, 24th March 2018. S&P signed after 2 months late lah, 28th of May 2018. So you can actually stretch your LED for extra 2 more months. So that's another area that HBA lawyers will fight again. Later lah, later. After VP.
Alright. Okay, sure. Just to inform, since you are on the booking payment, kalau ada yang kami terima berita, ada pembeli yang masih belum claim lagi booking fee tu daripada developer. So if you're paying that RM500 booking fee, you can claim it back from the developer, just contact them.
What is that to claim back from developer? Isn't it part of the SMP price?
No. For me, my bank doesn't consider it part of the SMP price, so we can claim back.
I see. Okay. We will discuss it when we come to it first. We will discuss it when we come to it. Albert?
Yeah.
Okay.
Okay, from Rosaimi Nazir. Thank you, sir. A lot of knowledge we get today. Oh, okay lah. A lot of knowledge we get today.
Dr. Shah, maybe you can encourage many of us to be part of the force lah. I mean, is it fair to say that those who are, signed the SNP earlier should come forward lah, right? Because this is for their benefit as well. Maybe you can give words of encouragement to these people to come forward.
Yes, true. I agree with you. I always say that enthusiasm is contagious. Enthusiasm. If you're enthusiastic to want to solve your matter, get together. As a group, you got a voice to speak, against the developer or to the ministers, all that. It is very important, like people like Nora, who stand up, initiate groups, all that. But without anybody leading a pack, there'll be no solution whatsoever. But thanks to Nora, she located me early this year in March. That's why Nora started this group. We had meetings. This is our second meeting on that. And we hope that more people will join in so that you all can have a voice to speak up for those people who cannot speak at all. There are a lot of people out there who don't want to stand up for their legal rights. They've got rights to claim for LAD. They don't want to. They allow developer to, sometimes allow the developer to brainwash them. And when developer says, kita akan muflis lah kalau you sue kita untuk LAD, that is one of the many threats the developer issue out. So therefore, do not be so worried about, developers threat all that. We always believe we got law in Malaysia. We just follow our contract in your S&P down here, but stand together as a group so that you all can have a concerted voice. Okay? Thank you very much.
So, Datuk Sang, there's a good question by Nurul Nana.
Okay.
Because Albert mentioned about 100 names is already sufficient. So
Yep.
we are afraid that if we say that 100 names is already sufficient, we just get enough just 100 people to want to contribute to the force. So is it true, or 100 people?
No, that is why I want to have a private discussion with the committee. All right. When we say 100, that one is just for the purpose of putting nama on the cost paper. All right. But you have said that you have got around 800 old people who are willing to support you in the action. So I want to discuss privately with the committee how to get this thing done.
Okay.
All right.
Okay. Okay. That's
Okay,
all.
sure.
Okay. Anyone?
Anyone else?
That's all.
Hi, Mr. Albert. Sorry, I got one more question. Okay, in the SPA, it mentioned that we have the right for the set off for deduction of the balance purchase price from the LAD. So, if let's say by the end of the date where the developer should deliver the vacant possession to us, they still unable to finish the project. Can we just proceed for the set off, or we still require for the vacant possession?
Okay, I think the set-off clause can be quite misleading in reality. Unless the LAD is very clear-cut, all right, very clear-cut that the developer admitted they owe you LAD, let's say for 5,000, and then your last payment is 15,000 to the developer, so then you can use this clause to set off. But when the LAD there's a dispute, here definitely there's a dispute, because we are arguing that the delivery vacant possession date is time frame is 36 months. They are going to argue that it's 48 months. So when there's a dispute, all right, so in other words, the amount of LAD is not determined yet. So when it's not determined yet, it's difficult for you to invoke the set-off clause. And then if you don't pay your last payment, the developer can then invoke the clause for late payment charges, late payment interest. Then you will be caught, So I think it's a bit dangerous to use that clause, the set-off clause, at the end of the period when you're going to take the key, because like I said, the LAD amount is in dispute. All right, it is in dispute. It is only workable for those cases where the LAD amount is very certain and developer is not contesting. The developer agreed and admitted the amount. But here, I'm very, very sure the developer is going to contest on the LAD amount.
Okay, thank you.
Okay.
Okay, if there's nothing else, Nora, I know, we should leave the meeting, and then you can have your private discussion with Albert. I've just sent Albert handphone, his card over to you already. You can speak to him directly on the matter.
Yeah, very on the number.
Send me the link to WhatsApp. All right, then
Okay.
I will key in and then we can have a short discussion.
All right, sure.
Okay, before you all need to go for prayer, right? What time is your prayer?
7 o'clock, nearly 7 o'clock already.
It's 7 something.
Yeah.
Okay.
All right.
Alright, so kalau tak ada apa-apa, kita minta diri.
Okay.
Okay, so I will wait for your link. Okay.
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 Thank you.
Adriana,
Thank you,
okay, Adriana.
everyone.
Thank you, everyone.
Dr. Chang.
All right.
Thank you,
everyone.
Alright, thank you.
Thank you, Adriana.
Your committee,
Thank you.
were nice with me. Okay.
Thank you. Bye.
Bye.
Thank you all. Bye.
Thank you.
Bye.
Okay, thank you. Bye.
Thank you, everyone.